I'd like to reserve 3 minutes for rebuttal.
Okay, 3 minutes.
So I'm Nancy Corley of the Nashville and Sumner County Bar, and I represent Tanya Hans, All Natural Lawn and Landscape, and A Greener Way. The first issue in this case is who is the tenant in the lease purchase agreement between the parties. The second issue is whether or not the trial court at summary judgment determined that there wasn't a valid option agreement because there was no purchase price after the initial 3-year term. And the effect of those two rulings at summary judgment was to basically dismiss Hand's suit for specific performance of the option agreement and leaving only a detainer warrant. So the third issue is whether or not there was a legal notice of non-renewal of the document by overnight mail or by hand delivery or by a notice that was introduced in the middle of trial. The other issue is whether or not the trial court erred in denying my motion to dismiss, both at the conclusion of the proof in the detainer warrant and at the end of the trial. These parties entered into a lease purchase agreement that provided several things. One, it provided that the tenant had a right to exercise the option during the term and the renewing and additional terms of the lease by giving notice of that right during that term or the renewing or additional terms. It also provided
Counsel,
that...
what is the purchase price after the renewal time period? So we've got the listing of the purchase price.
Yes.
in 1 year is set at $330, then $335, then $340. During the renewal time periods, during this extended time period, what is the purchase price on the property?
Our position is that it is $340,000. That it's because it's as the lease says, according to the renewing and additional years, according to or pursuant to the purchase price as set out in the lease, which is the $340,000.
That was the third year purchase
Yes, sir.
price.
That was the third year.
So they raised it every year, and then
Until the third year.
And then years later, you think the price is still the same?
Just as they did the rent. They raised the rent every year of the first 3 years, but not after that. So the lease amount remained the same during the entire history.
I thought the rent amount shifted in the 5th month.
I'm sorry, Your Honor.
I thought the rent amount shifted in the 5th month of the contract. I thought it started at 1108 and then shifted to 1500 in the 5th month of the agreement.
So the lease amount remained the same. It was an amount year 1, year 2, year 3, and after year 3 it remained the same. And our position is that the purchase price was set out as year 1, year 2, year 3, and after year 3 remained the same, just as the lease amount did.
Okay, let's shift back to who's the tenant.
Yes, sir. That's, I think, the key issue in this case.
The very beginning of the lease says it's between
Yes, sir.
Shams and All Natural Lawn and Landscapes.
Yes, sir, it does. And the signature portion of the lease, Tanya Hahn signs her name with no reference at all to her signing in a representative capacity, and furthermore prints her name in the space, Tanya Hahn's, in the space that is provided for the printed name of the tenant. Obviously, there are not many cases that have this scenario, and the only one that really does is Mudd versus Goose Tree. Their general rule is that if you sign your name just your name with no indication that you are signing in a representative capacity for anyone else, then you are individually and personally bound, both good and bad. Our position is what's sauce for the goose is sauce for the gander. If you have the liabilities, you also have the rights as the individual signor of that document. So there are a lot of cases that
Tennessee
have...
Supreme Court
I'm sorry?
Hasn't the Tennessee Supreme Court been refocusing on the substance of the agreement itself, though? And
Yes,
then the
sir.
substance of the agreement doesn't provide for her being bound.
It is like mud versus goose tree. If you sign individually, then you are bound. The substance over form, the cases, and Shams talks about all of the decisions after the substance over form, but most of the cases that are cited actually go before mud versus goose tree, and the only two that come after that are easily distinguishable on the facts, because they are cases that have to do with whether or not the person is a guarantor of the document, which is a little different issue. You can sign individually or as a representative or of another entity or as a guarantor, and the rules about guarantors are a little bit different. And the cases that are cited in the substance over form argument all have to do with whether or not someone is a guarantor of a document. So it's not quite the same issue. So if...
Who wrote the checks for the rent?
I'm sorry, Your Honor.
Where did the checks for the rent come from?
The checks of the rent?
Yes.
They came...
Was it out of an account of All Natural Lawn, or did Ms. Hans pay it?
They came all over the place. It's not in the record specifically.
Oh, it's not? Okay.
Because by the time we got to the trial, all we had left was the detainer action. So it wasn't developed at summary judgment because we are looking at the document from the four corners of the document as to who is the tenant.
Counsel, I'm curious. We have here an entity that's dissolved by the Secretary of State. We have an entity that's dissolved by the Secretary of State's office here.
Yes, sir.
Doesn't this become a periodic tenancy at that point? Aren't we sort of, we're no longer really in the land of this lease agreement?
Except for the point that if you look at the signature portion of the document, which is part of the document itself, part of the four corners of the document, not only does she sign her name, she prints her name in the space in which you print the name of the tenant. So not only is her signature there, but there's clear intention by the fact that she printed Tanya Hans as the tenant.
There's no language, though, in the agreement that specifies she's personally, individually liable, right? There's no. Okay.
No, there's no language of any kind of a guarantor, that she has any kind of guarantor status. Our position is that it's clearly shown in the four corners of the document that she signed, not in a representative capacity for anyone else, and additionally that she printed her name in the space for the tenant. And I think that's just as important as the fact that she signed her name, the fact that she printed Tanya Hans as the tenant. It's a little, it's not a usual situation, but the rules of who is bound under a contract, I think are pretty set. If you are going to be individually bound, you sign your name individually. If you are going to bind a corporation by your signature, then you have some language in that signature that says, I'm signing for. And there's no indication in the signature portion of that document that she signed for anybody else. So there's clear I think there's clear, I'm not sure what the right word is, but there's a clear intent that's expressed in the four corners of the document that she is the tenant and not All Natural Lawn and Landscape, even though that name is printed in the first paragraph, just like Liberty Cabinet Company was printed on the first page, on the first paragraph of the lease in the Mudd versus Goose Tree case.
The notice that was sent, non-renewal notice that was sent by the attorney, was sent in the proper form. I know there's a dispute about whether it should have been amended, but is there any dispute about whether it was sent in the proper form?
No, Your Honor.
Okay, so
Which is why it was such a ruckus.
What's the error in the trial judge considering that notice, a non-renewal notice that was sent by the attorney in December of 2020?
I think the biggest thing, Your Honor, is that had been sent in December 2020. We had a trial some 11 months later, and there was no attempt to amend the pleadings to include that. Obviously, my client, her testimony is that she did not receive it. It's not signed by her, and their business was closed during the time that it would have been delivered, and so
the second notice that there's the first one, whether it was mailed appropriately. The second one, they try to actually drop it off at the shop here.
Yes.
Is there testimony in the record from Ms. Hans that she never saw that notice?
There's testimony that it was not delivered to her. I don't know whether there's any specific testimony that she did or did not see it.
Okay.
I don't know that she saw it that day, but there's no proof in the record of when she saw it. I have 11 minutes, 10 seconds left. Our position on the notice is that the lease specifies notice in a particular form and that no conduct of the parties will vary that. The judge, in effect, changed the terms of the contract in his decision.
Thank you.
May it please the court, my name is Mary Beth Hagan. I'm here on behalf of Mr. Mohammed Shams and Shams Properties, LLC. I would first just note a nuance that Ms. Hans is the only appellant in this case. The defunct entity did not appeal and a Greener Way LLC did not appeal. Then I would point to this question about who the tenant is. I think the point that Ms. Hans is missing is that, just like Your Honor said, the Supreme Court has refined the law, and to accept Ms. Hans' argument, you will ignore the rest of the lease. Because the lease starts in with a definition of what does the word tenant mean in this document, and it is the LLC, All Natural Lawn and Landscapes. Everywhere in the lease, it references the defined term tenant with a capital T. On the purchase option section, everywhere. Then, Ms. Hans would have you only look at the signature block, which is where Tennessee Supreme Court has moved away from looking at only that one section. And her argument is that Ms. Hans signed and printed her name, and therefore she's personally on this lease. But you have to look above it. In witness whereof, landlord and tenant, capital T, have caused this lease to be signed upon the day and year first written above. Then
Would you agree that if she is bound, individually, personally liable, then there is something to the argument of what's good for the goose is good for the gander, in terms of if she's personally obligated on this, can't she also enforce its terms to her benefit, not just detriment?
Yes. But then you go to the question about the option and the fact that there is no purchase price after year 3. And so if you look at the 4/8 versus Salem case, it says that if the contract does not, if the option, so it's in our same factual scenario, if the option does not state a purchase price, the court will not create one for the parties. don't know why these parties didn't do that, but they didn't. They only listed a purchase price for the first year, the second year, and the third year. The agreement says that all of the agreements between the parties are encompassed herein in paragraph 31. So even if, Your Honor, were to find that Ms. Hans had some rights or obligations under this lease agreement, she doesn't have the right to exercise the purchase option because it wasn't exercised in years 1, 2, or 3. In the MLG Enterprises case, that's the Supreme Court case from 2016, that's where the court started really talking about this substance over form, and that's after Mudd versus Goostree. So I wanted to distinguish the case. That's what Ms. Hans hangs her hat on, is this Mudd versus Goostree case. That's an unreported case from this court. It's pretty short. It really does not talk about what the rest of the language in the lease talks about, so we don't know. But what we know in our lease is that every single reference deals with tenant, capital T, defined as the LLC. So that's the distinguishment between the Mudd versus Goostree case and where we are today in the law. Then you fast forward to 2018 and look at the Teal Properties case, where this court, I think, went even further, because in Teal Properties case, there was a signature on behalf of the company, and the people signed under the company name as co-owner. Then they signed again beside the word individually. And because nothing in the body of the lease referenced whatsoever a personal obligation or right, this court found that just because they signed beside the word individually, the intent of the parties from the four corners did not reference any personal rights or obligations of those people. That's what we have here, is Your Honors have to look at the entire lease document from beginning to end. And in doing so, you will find nothing that gives Ms. Hans any personal rights or obligations under this lease.
So in terms of the purchase option ending after the third year, one thing that's I find challenging on that is language that I think is omitted in your brief, is including the optional and renewing lease years language. Doesn't that language point towards a continuing purchase option in this case?
Yes, I think it does point to a continuing purchase option, but they left out the purchase price. And that's an essential material term. And so to say that in year 14 of this renewed lease, a party can exercise the right to purchase it from the third year price, that's not, when you look at the document as a whole, that's not what the parties agreed upon. So I think what the parties did was left it to be negotiated, probably because it was far out in time. And it's understood that property increases in value, hopefully. And so
there's no negotiation language, though, or no sort of system for determining price, right? That's provided for. Okay.
Correct. And so I think that it falls under the 4/8 versus Salem analysis, in that it's just part of, it's something that the parties did not include in their agreement.
There is some dispute over whether the initial notices were sent properly, because an overnight carrier, I believe, was used instead of the U.S. Postal Service, but there was supposed to be registered and tracked and everything. Could you speak to that?
Yes, Your Honor. Actually, the proof does show that it was with the U.S. Post Office.
Okay.
It was just that it was overnight delivery. Mr. Shams purchased, and the receipt is in the record as an exhibit. He purchased for a tracking number, he purchased for a signature upon delivery, and he purchased for a return receipt. I think that really where it shakes out is that there is a particular product that's called registered mail, capital R, capital M. A particular product called certified mail, capital C, capital M. That's not on the receipt. The court found our position is the lease has lowercase, certified mail or registered mail with the U.S. Post Office, and Mr. Shams purchased the same features at the U.S. Post Office. He had a tracking number with the U.S. Post Office, and there would be a signature upon delivery and a green card return receipt. And so it ultimately did not get delivered, but the notice provision in the lease says it's effective upon mailing. Mr. Shams really wanted Ms. Hans out of his property. He continues to really want Ms. Hans out of his property. And so his wife on the same day hand-delivered the notice to the property. And Ms. Jones, who works the front office, delivers rent checks, receives rent checks, which that's part of the notice provision too, is that rent has to be sent by certified or registered mail. That was never done. She did not receive with her hand, but it was undisputed that the notice was placed on the table. And then there was disputed testimony about whether Ms. Hans came to the shop and saw that notice. I think Your Honor asked that question to Ms. Corley.
So both sides varied from the lease in terms of sending things that they were required to send by a particular way, registered mail or whatever.
Yes. Yes, because
some of it was hand delivery, some of it was just plain old mail.
Right. The court specifically found that Mr. and Mrs. Shams were more credible than Ms. Hans, Mr. Jones, Mrs. Jones, and Mr. Hans. And there was a lot of testimony about what Ms. Hans did after that notice was hand delivered, just to show that circumstantial evidence that we had to show that Ms. Hans knew that Mr. Shams was attempting to terminate that lease and had delivered a notice of termination.
And the December delivery was using the process specified, even from even a technical understanding, it was using registered certified mail.
Yes.
Of course. Why was it appropriate, in your view, for the trial court to consider the December mailing?
Because this was a case where we were not, number one, under Rule 15.02, amendments shall be freely allowed, even after judgment, if the presentation of the merits would be subserved thereby and there's no prejudice shown. So that's the motion that we made to ask the court to amend it. The reason why it's appropriate is because Shams Properties and Mr. Shams were asking only for possession and not damages. So the trial took place in November of 2021. The December 2020 notice would have terminated the lease March 2021. When Mr. Shams originally tried to terminate the lease, it would be terminated March 31, 2019. Ms. Hans has been in the property, continues to be in the property until this day. So whether the courts find that the lease was terminated in 2019 or the beginning of 2021, it really doesn't matter. She's been in possession the entire time. So it might make a difference if there were a claim for damages and that affected the amount of damages, but that's not part of our claim. So there's absolutely no prejudice. And if the court had denied that motion to amend, which, mind you, I think we all understand that review of that decision that the court made is abuse of discretion. But if the court had denied the motion to amend, these parties would be back in a lawsuit. If he had said the 2019 wasn't appropriate notice of non-renewal, then everything would be restarted again. And that just doesn't make sense from judicial economy when all we're asking for is possession, not an issue of the damages amount given whatever time the lease is deemed terminated. Because I don't have a rebuttal, I'll just touch on the last issue, which is that the notice or the motion for involuntary dismissal made by Ms. Hans at the end of Shams Properties proof, that the court erred in denying that motion. Ms. Hans proceeded to present proof, and so under the law of the Adelsberger case, that's a waived issue. I really don't have much more unless your honors have questions, but just to follow up on something that I probably intended to say in further answering your last question. When Shams Properties asked counsel, me, to send the notice at the end of December 2020, it was because we were trying to do a belt and suspenders approach, and we knew that at that point we could do certified mail through the U.S. Post Office. We could send it to All Natural Lawn and Landscapes LLC. And because that company, Ms. Hines, and the occupant are all represented by Ms. Corley, I secondly sent it to to Ms. Corley by certified mail. I felt that was necessary for my ethical obligation since that defunct LLC has legal counsel. The response from Ms. Hines is, well, I didn't receive it. We were closed Christmas week, so I didn't receive it. Again, that's not the analysis because the notice provision of the lease references delivery occurs upon depositing in the U.S. mail. Thank you.
Ms. Corley.
Say just a few things about the notice, kind of in reverse order. I think it's important to note that not only was the notice not sent by the type of mail that was specified in the lease purchase agreement, it was sent to another, it didn't even get the name right. It was mailed to All Natural Landscaping, and the name of the entity is All Natural Lawn and Landscapes. It was returned by the post office as undeliverable. So the notice of the notice of January 2019, not only was it mailed by overnight mail, the name on the envelope was incorrect. And the only testimony in the record that I recall was whether or not the features of certified, registered, and overnight mail. There is attached in this record a large document from the United States Postal Service about those three kinds of mail and that they are separate and distinct. I think the only testimony that showed up in the record was that it was all the same thing was Mr. Shams, and I don't think that he's the person that can testify that he complied with the requirements because he understood it was the same thing. As far as the option agreement, one thing I want to point out, it says clearly in the lease that this agreement will not last beyond 15 years. And the court specifically make reference in its order that it was prepared by Rusty Rust, who was Mr. Shams' real estate agent. So in this paragraph, if it wasn't going to last beyond 3 years, then it was a gotcha prepared by Mr. Shams' real estate agent.
Counsel, isn't it possible the parties did intend for the purchase option to survive 3 years, but they just didn't put a price? And if they didn't put a price, don't we not have a valid purchase agreement?
Except there's nothing in there that indicates it was to be negotiable. And Mr. Shams is the one who, by his agent, prepared this document. And if he set it up as a gotcha, then that is something that we have the right to be tried.
The last listed amount, though, says third year. The last listed amount says third year, $340,000. How do we apply that amount after the third year? And it's first year, second year, third year, and then there's no amount listed after that. It's not third and ongoing.
So again, there was no amount listed for the rent after the third year, and it was remained the same. This is a messy case. It's not straightforward. It's not an easy contract or situation to deal with. There's just a lot of loose ends hanging out there.
Thank you. Thank you both. So would you please call the next case?